Hello everyone, welcome back to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Survival and wrongful death action. The Supreme Court held that where an action for unseaworthiness is combined with an action under the Jones Act, a state court cannot apply to the former a shorter period of limitation than Congress has prescribed for the latter. The court reasoned that the seaman's full remedies include claims for the both unseaworthiness and Jones Act negligence, as this could only be done in a single proceeding under the rule stated in Phillips. The state's time limitation on the unseaworthiness was said to effect in substance a similar and therefore improper limitation of the Jones Act claim, which has its own statutory limitation. While the unseaworthiness claim must be allowed at least 3 years to be proved in a state court, it has occasionally been afforded a longer time limitation. Some courts have demonstrated an inclination to extend the doctrine of leases to a period greater than the 3-year statute of limitation provided by the Jones Act, either by applying a state statute by analogy or by finding a lack of prejudice against the defending party. Unseaworthiness and maintenance and cure seem to be treated identically as respect the doctrine of leases. It has been held that where a seaman sues under the Jones Act in a state court, the defendant cannot obtain removal to the federal court on the grounds of diversity of the citizenship because a claimant under the Jones Act has his choice of the forum. There would seem to be no reason why a defendant could not remove a suit brought in a state court solely on a general maritime law claim, if the proper diversity of citizenship be shown. In cases where a Jones Act and unseaworthiness claim have been proved together in a state court, the defendant, in arguing for removal, has urged that such a joinder of a general maritime law claim with the Jones Act claims allows removal of both claims by the defendant. The courts have uniformly rejected this argument. In denying removal in such a situation, the courts have found support in the reasoning discussed above that the Jones Act and the unseaworthiness doctrine do not state separate and independent claims, but are rather one cause of action and hence should be treated similarly. The same reasoning would apparently preclude the defendant from removing the unseaworthiness claim to the federal court, leaving the Jones Act claim to be tried in the state court, since this would be splitting the same cause of action. Although it might be possible to remove the maintenance and cure claim to the federal court and try it separately there, the danger of duplication of damage argues against such a procedures. Although under general maritime law there is no remedy for wrongful death, nor for survival of a fatally injured seaman's cause of actions, the Jones Act provides both a cause of action for wrongful death and the survival of a seaman's cause of action for personal injury. But although there is no survival for maintenance and cure claims under general maritime law, a seaman's death resulting from a failure of providing maintenance and cure has been held to be a personal injury arising from negligence and within the purview of the Jones Act. The Jones Act apparently does not provide for the survival of an injured seaman's cause of action based on unseaworthiness. Turning to state-created cause of action, a claim for wrongful death cannot be brought pursuant to state wrongful death statute, where the Jones Act provides a claim for the seaman's death. This principle has its origin in the case of Lindgren v. United States, in which a suit was brought to recover damage for a seaman's death under a Virginia wrongful death statute. The Supreme Court, in holding that the Supreme Court, in holding that the Jones Act was applicable and that an action under the Virginia wrongful death statute would not lie, stated that the Jones Act covers the entire field of liability for injuries to seamen, is paramount and exclusive, and supersedes the operation of state statutes dealing with the subject. In a dictum, the court further stated that the right of action given the personal representative by the Jones Act to recover damage for the seaman's death when caused by negligence is necessarily exclusive and precludes the right of recovery of indemnity for his death by reason of unseaworthiness of vessels, irrespective of negligence, which cannot be acted out by resort to that statute of the state in which the injury was received. This dictum has become the general rules under which an unseaworthiness suit based on a state wrongful death statute will not lie where the deceased was a seaman whose death was covered by the Jones Act. As respects the survival of a seaman's cause of action for pain and suffering, however, the application of state survival status has been approved. Even though the seaman had a survival claim under the Jones Act, this seems contrary to the board language in Lindgren, which would appear to foreclose such a result, where the deceased is not a seaman and hence cannot sue under the Jones Act. An unseaworthiness claim based on a state wrongful death statute will lie. Under general maritime law, a seaman may obtain a maritime line based on a personal injury claim. In Palmas v. S.S. Pinar del Rio, wherein a seaman sought to obtain a maritime line pursuant to a Jones Act claim, the United States Supreme Court held that the Jones Act does not afford a maritime line. Thus, a seaman can apparently seek a maritime line for unseaworthiness and for maintenance and cure claims, but not for Jones Act claims. In view of the McAllister and Picklips case discussed above, which demonstrate the coalescence for many purposes of the unseaworthiness and Jones Act claims when arising from the same facts, this result would appear to be anomalous. When a seaman dies of his injuries, general maritime law does not permit a line to be obtained for his survival or wrongful death. However, a maritime line may be obtained under a state wrongful death statute. In the Tungus v. Skovgaard, a worker who has not a seaman was killed aboard a ship. The descendants administered commenced a libel in rem based on the New Jersey wrongful death statute pursuant to an unseaworthiness claim. The Supreme Court upheld the conclusion of the Court of Appeals that the unseaworthiness claim was encompassed in the New Jersey statute. The court did not discuss and thus apparently approve the bringing of the libel in rem terrobi affording a maritime line under a state wrongful death statute. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.